Is the opposing party in a divorce or custody case failing to follow a court order and you want to hold them accountable? I'm Matt Dolan with Dolan Divorce Lawyers in Connecticut, and today I'm going to explain how to file a motion for contempt in Connecticut Family Court. Now, before you file the motion, you should determine whether the court could find the opposing party in contempt. And in order for there to be a finding of contempt, the court must fulfill three criteria. First, they must establish that there is a clear and unambiguous court order. Then they must establish that the opposing party has violated that court order. And finally, they have to establish that the violation was willful. An example of a willful violation is an opposing party who has the money to pay child support, but they simply choose not to pay it. But what would not be a willful violation is an opposing party who unexpectedly lost their job and has absolutely no income or assets from which they can pay child support. If you brought a contempt against that person, the court may not find that the violation was willful, as they did not have the means to pay child support due to the fact that they lost their job. Another example of a willful violation is when somebody was supposed to drop a child off for the other party's parenting time at 6 p.m., for example, and they just choose not to do so. They decide to do something else. That would be a willful violation. However, if the opposing party got caught in a snowstorm, there was a medical emergency, or their car broke down, those circumstances are outside of their control, and if they missed that 6 p.m. drop-off time, the court likely would not find that the violation was willful due to the outside factor that prevented them from being there on time. Now, if you feel that there was a willful violation, you can file a motion for contempt, which you can find online by searching for Form JD-FM-173. Looking at that form, you first have to check off the before or after judgment box. So if you are filing the motion for contempt before your divorce or custody case is finalized, then you click the before judgment box. However, if there's already been a final judgment for divorce or custody, then you click the after judgment box. You then fill in the judicial district where your case is being heard, the town, the docket number, the name and address of both parties. And then if you are the plaintiff, you check the plaintiff box. If you're the defendant, you check that box. You fill in the date of the order that was violated, as well as the name of the opposing party who violated the order. You then have to fill out all the details of the violation. So you should be specific about the exact order and the language in that order which was violated, and then a thorough explanation of how the order was violated. So if child support is not being paid, you should include a description of the amount that has been paid, if any, and what is outstanding. If there was a violation of a custody order, you should put exactly what happened as to the violation of the custody order. You then, again, fill out the opposing party's name, who you want to be found in contempt, and then you sign, date, and enter your contact information at the bottom of the form. Now, if this is a pendente lite motion, so it's before judgment, then you should fill in this box with the date of the motion and the name of the parties to the case, as well as their addresses, who you have to send a copy of the document to. But if this is a post-judgment motion and there are no other pending motions, then you do not have to fill in this section, as you will have to have a marshal serve the opposing party. You should then bring the motion for contempt to the clerk's office of the courthouse where your case is being heard, and the clerk will fill out the second page of the form. There is no filing fee for a motion for contempt. However, after bringing the document to the clerk's office, you will have to hire a marshal to serve the other party if it is a post-judgment motion for contempt. If it is a pre-judgment or pendente lite motion for contempt, then you just have to email a copy or mail a copy to the opposing party in the case. Now, after the opposing party is served, you will then be assigned a court date, at which you and the opposing party will attend court. And you will first meet with family relations at the courthouse to try to negotiate a resolution to the motion. However, if you're unable to reach an agreement, then you will have to have a hearing in front of a judge where the judge will enter orders. And those orders can include no more violations, that the opposing party actually follow the court order. The court can order financial sanctions. They can order the payment of attorney's fees for any fees that you incur in having to file the motion for contempt. And the court can also order incarceration. For example, if there is a significant amount of child support that is owed, the court can put somebody in jail until they make arrangements for that outstanding child support to be paid off, or at least a portion of it. So those are the basics on how to file a motion for contempt here in Connecticut. As usual, if you have any additional questions, you can contact our office. And if you're looking for representation in a divorce or family law case here in Connecticut, we would invite you to contact our office as well.